A judge in Texas has decided not to wait for Elon Musk to take the helm at Twitter to punish big tech companies for censorship. Now, private citizens can do it. So this is a law in Texas that was struck down last year, but a judge just this week put it right back in place. It now says that tech companies with more than 50 million users, such as Facebook, Twitter, and Google, and the likes, can sue these companies if they block, ban, remove, deplatform, demonetize, deboost, restrict, deny equal access or visibility, or otherwise discriminate against expression. Now, interestingly, it does not say that these tech companies can't do those things. It says that private citizens can sue them if they do, right? So they're deterring through litigation. This is a lot the same way that the Texas abortion ban works, is it does not outlaw abortion. It allows people who are performing or participating in abortion to be sued by private citizens. Okay, so now we're going to see how that works, right? So that law has gone to the Supreme Court. This one, we will see how far it goes, and I predict it will go a lot farther, because can we just take a moment to realize that the law does not prevent these companies, and it also opens the door for them to be sued for doing these things, whereas they previously could not be sued.
Yeah, this is going to open up.
Which is crazy, right?
Well, it's going to.
Well, just the part that they couldn't previously be sued. Like, we don't have that protection as citizens or our small business.
Well, what's crazy to me, you couldn't have sued them before. Like, hey, you deboosted me, or you deplatformed me. I mean, I guess they could have sued and they would have gotten thrown out. They could have wasted a whole bunch of money, right? You couldn't.
Yes.
You could still bring a lawsuit, like, but the lawyer. I mean, I guess the judge could just be like, well, no, we're just going to throw this out because there's nothing that says you can do this.
In much the same way that tech companies use an act that will prevent them from being liable for anything that's posted on their platform,
Right.
They had similar protections around being sued for whatever they did to either boost or deboost certain users. It's really interesting, this deny equal access, right? So if certain things are being suppressed, then that also would be open to litigation.
Yeah, I mean, this is going to open it up an absolute floodgate. So this is Texas, right?
Yes.
So, and I don't understand why you have to be a resident of Texas to do this. I was a little confused about that. Why?
Especially because the first suit from the Texas abortion ban came from a man in Alabama.
Right. So, and Texas, I mean, we know the Eastern District of Texas, or wherever where all of those patent laws are brought up against in Texas, and they do it from outside. You don't have to be a Texas resident to bring those patent violations,
yes.
Which happens all the time in Texas courtrooms. So my thought is like, well, this is, first of all, Texas is going to be the first stop on this train. Florida is going to be next. So,
yes.
As soon as Texas passes this now, you're going to see Florida doing the same thing. You're going to see...
Followed by Oklahoma, followed by
North
Michigan.
Dakota.
Yes.
You're going to see a whole host of specifically
California will be
red
last.
States. Yeah, California probably will never have this happen. But it wouldn't stop people from suing these companies. And now it's going to open up a floodgate of litigation. And I just anticipate you're probably going to start to see a lot of class action lawsuits.
Yes.
Because and that's where the big money is going to come from. It's not going to be just like little one-off lawsuits, because that's a lot of money to sue, and a lot of people don't have that extra money. Like if you're like a content creator on Twitter or Instagram or something like that,
an influencer,
probably not rolling in tons of money. And so are you going to like file a lawsuit against one of these platforms in Texas on this? But you might join a massive class action lawsuit. And some of these law firms are probably salivating already to get their hands on bringing multi-billion-dollar lawsuits against these companies for being deplatformed, blocked. And you could just go down the list. It wouldn't be difficult for these people to find out who had been banned on Twitter or blocked on YouTube.
All of that would be discoverable. This is what I think is so interesting, right? Is when you open yourself up to a litigation, you have to ask the other party for a litany of things that you think would prove their case, and they have to give it to you unless they have a good reason why not to. So for instance, you don't have to hand over marital communication, right? So if Clayton and I have texts, no one can in discovery ask for it because there is marital privilege. So, okay. But for the most part, you have to hand over information. So right now, tech platforms ban and demonetize users and suppress them and have no burden of proof as explanation. They just sort of punish them. You can say, you can contest it, but once they've decided to do this, that's it, right? So this will change as courts tackle this issue. And some say it could go all the way to the Supreme Court because you as a user are saying, you have taken away my freedom of speech, right? And so if your platform now is functioning as this town square, a global town square, but you're saying, I don't have the right to speak inside of it because my views are controversial. Well, the Supreme Court has already ruled that controversial views are protected, that hate speech is protected, right? So are they then protected on these platforms because they serve as this town square? And then will they be open to discovery about why they have censored certain things? So let's just play this out, right? All of that, the tech companies will now know that their internal decisions about blocking some people over others will be discoverable, right? So the discussion around why they suppressed the Hunter Biden laptop story will be discoverable.
Right.
All of that stuff. Will a judge and a jury hold these blockages against other posts that were allowed, right? So could you say, well, we don't let you say this thing about the COVID vaccine. And would you say, well, so-and-so said this about the COVID vaccine and weren't.
So in these discovery moments, there's going to be a lot of things that will be uncovered, and it's going to make these tech companies very uncomfortable because we're going to start to see favoritism, right? We're going to start to see that, as we saw from the Project Veritas leaks of the Twitter story, right, and the Twitter exposed stuff that we've covered here on the show, right? You have these Twitter employees sitting there basically saying that, oh no, everyone I work with is lefty, and they're totally anti-right, and our platform is totally anti-right wing. And so, so you're going to start to see, like, okay, is this endemic? Like, is this systemic? Is this part of the whole internal workings of this company? And you're literally blocking certain speech, which under the Supreme Court is illegal. So this is going to go to the Supreme Court.
Well, it speaks to the sort of veracity of these Project Veritas leaks, right? So, okay, you got some bro who's drinking in a bar saying that Twitter censors the right more than the left, explicitly saying that, right? But it's not an official position, and Twitter does not ordain those types of interviews. But the law was born out of Texas Republicans' frustration that the tech platform discriminates against their party over others. So when you have someone who says, yes, that's true, is that admissible? Or is that sort of not admissible in the court? But here's what will be admissible is the discussion about why you were deplatformed. So let's say that me, Natalie, was deplatformed for something that you're not supposed to do by woke Twitter, right? Let's not give an example because I don't want to do those things, right? Let's say that I was deplatformed for saying something so offensive like watermelons are gross and not worth the effort, which I actually don't like watermelon. It's too hard to cut. It's a pain. It goes all over the counter. It's delicious. Like everybody loves it, but I'm stuck with a big old mess.
Well, here's the point. Like, yeah, maybe my platform here on YouTube, maybe I own YouTube, and I think like videos about watermelon, you're prejudiced against watermelons.
Okay. So I say watermelons are not worth it, right?
Right. And in our terms of service, we say, we're pro watermelon.
You say that, right? And then you later on say, I think she was right. I've spent a lot of time cleaning seeds off the kitchen counter. Watermelons are actually not right. But I got deplatformed and you didn't, right? Then the discussion inside Twitter between executives talking about, should we deplatform Natalie? I don't really like her anyway. She sometimes can be a bit condescending.
And abrasive.
And and also she's not that warm. And so let's take her. She could be kind of cold. She's a recluse. She says what she has no filter. So we're going to deplatform Natalie over Clayton.
But this is, without saying it specifically, it's around COVID, right? These are the discussions that certain people were able to get away with talking about things around COVID, and others weren't, and others were deplatformed for talking about it. And we want to know the internal workings of these tech companies. And now I think we're going to find out.
We will get those because those things will be discovery.
Right.
And so will a judge and jury say, well, you can't sanction Natali around watermelons and not Clayton. So if Clayton was continuing to say bad things about watermelon and Natali was deplatformed for it, why were those decisions made? Was it actually a violation of my freedom of speech? And also that kind of speech is protected. It is unprotected, right? I can say whatever I want about whatever produce.
Part of me also feels like that these platforms are places where people work, right? If you're a content creator, you're making Twitter money by producing content for their platform. Like, you know, Twitter makes money off of you publishing tweets. YouTube makes money off of us publishing content and videos here, right? And so in many ways, it's almost like a work environment, you know, where the same kind of laws and things that we think of in an office building about speech, you know, protected speech and these types of things should be protected here as well. And so I think you're going to see, again, we talked about Texas. I think Florida, these other states are going to start to roll in on this as well. They're going to say, hey, us next, us next.
Right. But what would Twitter's defense be, right? We blocked the Hunter laptop story. Here are all the internal emails where we decided to do this, and we did it because it violated whatever. Like, as long as there is a user agreement that says you can't do this specific thing, then that is their line of defense. Look,
and then the user signed up for it and did, you know,
right. But if it is not actually something, so we will see Twitter change its terms of service to sort of lay out all the ways that you're agreeing to this kind of censorship.
It's going to be a 800-page terms of service. Right?
But they still then will have the burden of proof of executing equally, right?
Right.
So if now it says you cannot shit talk produce, you have to like all fruit equally, right? And then I'm punished and you're not, that is still, I think you still have a case.
Yeah, it'd be interesting to see. I mean, we've been through similar stuff, and to see like, okay, we've covered certain stories, and then another channel does the exact same story, almost in the, you know, in similar way, and they're fine.
Yeah.
Nothing happens to them. Or the White House releases information. Like the White House last week published their story on Twitter about vaccines. And guess what? That was a total lie, by the way.
Another thing that's interesting is that it also gives you the opportunity to litigate if you think your channel has been denied access. So if something is being algorithmically suppressed, right? And so for that reason, you also can sue, and you would get information about why they did that. And if they did that, and they would have to prove either that they didn't, right? That they never messed with your algorithm, or they would have to say why.
Oh, I would love that. And this is why I want it in more states. And why do you have to be a Texas resident? Because there are big channels that have publicly talked about being
don't say the content, just things that
I'm trying to find the word in my head. Just give me a second. It's shadow banned.
Yes.
You know, I mean, Tulsi Gabbard has talked about being shadow banned on YouTube. And there's other people who have big channels that have been talked about shadow banning. So what we'll learn more about shadow banning. Like, what internally are they doing? Like, people are publishing content, but no one's seeing it, because whatever they're doing internally is suppressing that content and keeping it hidden from users. And
so if I were the lawyers inside of these big tech companies, I'd be like, look, either you don't censor people unilaterally, or if you do, you don't have incriminating discussions on email that we have to turn over, or we just make it fair. How about we just do that so that we don't get sued?
There's probably a lot of documents being burned tonight in these tech companies, you know, like hidden, deleted, like, oh my God, because if this goes through discovery, we're going to start to learn some shit. Let us know your thoughts about this in the comments below. Thank you so much for subscribing to our channel. You know, we've been banned, we've been blocked, we've been censored. That's why we started our own website, to stay connected with you for free.
That's right. So head on over to redacted.inc and make sure you're connected with us. You can sign up again at redacted.inc, not .com.